Judicial privilege, a form of deliberative process privilege. The court records, which are pre-decisional and deliberative in nature, are thus protected and cannot be the subject of a subpoena. The document is a pre-decisional if it precedes, in temporal sequence, the decision to which it relates. A material is deliberative, on the other hand, if it reflects the give and take of the consultative process. The key question is whether disclosure of the information would discourage candid discussion within the agency. Judicial privilege is an exception to the general rule of transparency as regards access to court records. Court deliberations are traditionally considered privileged communication. Summary of rules. The following are privileged documents or communications and are not subject to disclosure. Number 1. Court actions, such as the result of the raffle of cases and actions taken by the court in each case, included in the agenda of the court session of acts done material to pending cases, except where a party litigant requests information on the result of the raffle of the case, pursuant to Rule 7, Section 3 of the Internal Rules of the Supreme Court. 2. Court deliberations or the deliberations of the members in court sessions on cases and matters pending before the court. 3. Court records which are pre-decisional or deliberative in nature, in particular documents and other communications which are part of or related to the deliberative process, that is, notes, drafts, research papers, internal discussions, internal memoranda, records of internal deliberations, and similar papers. Additional rules. 1. Confidential information secured by justices, judges, court officials, and employees in the court of their official functions mentioned in 2 and 3 above is privileged even after their term of office. 2. Records of cases that are still pending for decision are privileged materials that cannot be disclosed except only for pleadings, orders, and resolutions that have been made available by the court to the general public. 3. The principle of committee or interdepartmental courtesy demands that the highest officials of each department be exempt from the compulsory processes of other departments. 4. These privileges belong to the Supreme Court as an institution, not to any justice or judge in his or her individual capacity. Since the court is higher than the individual justices or judges, no sitting or retired judge, justice or judge, or not even the Chief Justice may claim. Requirements for decisions and resolutions. Section 13, Article 8. The conclusions of the Supreme Court in any case submitted to it for decision en banc or in division shall be reached in consultation before the case is assigned to a member for the writing of the opinion of the court. A certification to this effect signed by the Chief Justice shall be issued and a copy thereof attached to the record of the case and reserved upon the parties. Any member who took part of, or dissented, or abstained from a decision or resolution must state the reason therefor. The same requirement shall be observed by all lower collegiate courts. Section 14, Article 8. No decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based. No petition for review or motion for reconsideration of a decision of the court shall be refused, due course, or denied without stating the legal basis thereof. A resolution, not a decision, within the meaning of Section 14, Article 8. This mandate applies only to cases submitted for decision, that is, given due course and after the filing of briefs or memoranda and or other pleadings, as the case may be. It does not apply to other order or resolution refusing due course to a petition for certiorari. From the case of Nunal versus Court Commission on Audit 1989.